Good evening, sir.
Very good evening. Very good evening, Ekta. How are you?
I'm fine, sir. Thank you for asking. I hope I'm audible and visible.
Yes, you're right. Okay, so let's start with the session, Ekta. Just so you have done your LLB from AIL, Army Institute of Mohali, right?
Yes, sir.
So, is this the seat which you had secured in open quota, or you're having any kind of benefit?
So my father was in the army. He served in the army.
So, and you are currently doing LLM also, right?
Yes, sir.
So, do there is any specific specialization?
So my dissertation, which I'm currently working on, is based on constitutional law. Although
Okay.
my subject, the specialization was in criminal law.
So you have done your LLB in 2022, and when you have taken admission in LLM
So 24,
in
2024.
24.
Yes, sir.
So it is a 1 year LLM.
1 year LLM, sir. I got done with my exams last year itself, but my dissertation, I got an extension for my dissertation.
It is a regular course.
Regular course.
So how you are managing practice along with LLM?
So I started practicing again after 20, after I completed that LLM.
So just tell me why you want to be an ADA. Like you are having a LLM also. Why not academics?
So while academics is also a very coveted field to be in, I pursued a master's in law to with the only purpose of supplementing my education with a little more detailed uh, law education. Plus, I also wanted to pursue masters in order to hone my research skills. I believe that would really help me in pursuing the field of an ADA. Because the ADA field also requires a lot of researching in order to secure the right amount of convictions and the right trial. So ADA, I feel, is something would give me a platform to play a very proactive role in assisting the judge in order to secure justice for the victims.
So as this is the post of assistant district attorney, can you please tell me what is the hierarchy in the Department of Prosecution?
So the Department of Prosecution, it's headed by the Director of Prosecution. And
Hmm.
at the district level, there is the Director of Prosecution, there's deputy directors, and then there are district attorneys and the assistant district attorneys, they are subordinate to the district attorney.
So who is deputy DA?
Right, sir. The deputy directors of attorney are also, they are subordinate to the district attorney, but they are superior to the assistant district attorneys.
So just tell me, like, what kind of key responsibilities ADA is required to uphold?
So the ADA is required to represent the victims in the criminal cases. They represent the state of Himachal Pradesh. In civil matters as well, wherever the government is a party. In
Hmm.
such cases, the ADAs are supposed to represent the government in civil matters.
Okay. So, as had you gone through with the new criminal laws?
Yes, sir. I've taken a view of the new criminal laws as well.
Okay, so new criminal laws in the procedural law, it is appearing to be more victim centric. So,
Yes,
can
sir.
you please tell me, like, what are the new factors which are there introduced in the BNSS?
So a lot of victim-centric provisions have been introduced, such as the foremost is the introduction of the provision of an electronic FIR. So any person who wants to get an FIR registered, if they would not have to go to the police station directly. They can get an electronic FIR registered, although they would have to get it signed within 3 days of getting the EFIR registered. Apart from that, sir, I believe in the course of investigation uh, and other procedures, audio, video, electronic means have been introduced. And I believe that is also a step in the right direction to make the procedure more victim-centric.
Uh, in the new criminal law, like in the BNSS, we are finding that certain time frames are there now. Like
Yes, sir.
certain things are to be are required to be done within a particular time. So can you please tell me, like, what is the time for framing of the charges?
So I am unfortunately not able to recall the time for framing of charges.
So, can you please tell me, let's suppose accused makes a application in the court that he want to go for plea bargaining, right?
Right, sir.
And let's suppose you are the prosecutor in that matter. Now, on what grounds you can raise the objection against that application?
So, in case the accused has filed an application for plea bargaining, the one ground could be that he has already committed a similar offense, and therefore he should not be allowed to let the application be allowed. The application should not be allowed for plea bargaining. Secondly, a ground could also be raised that the accused has not come in voluntarily. That could be a ground of opposing the application. Thirdly, I believe, sir, if it is a matter against the community or women or children under the age of 15 years, or if it is a grievous offense, in such cases also plea bargaining should not be allowed. That could be a ground for opposing the application.
Just tell me, suppose police officer produces a person before the magistrate, right? And you are a APP in that particular case. Now, the before the production of the magistrate, definitely the police officer will also inform you that we are producing a person before magistrate and we are going to seek the remand in the matter. Now, being a public prosecutor, how you will convince the magistrate that remand to be given?
So, in order to secure remand, it is important that there is still a lot of material or evidence that crucial evidence that has to be taken from the accused, and his custody is therefore required to ensure that he does not, one, tamper with evidence. Second, if he does not, he is at a flight risk, or third, his police custody is needed in order to secure his presence during investigation, and fourthly, any crucial evidence that we need to extract from the accused.
Okay, so let's suppose that the magistrate is framing his mind that whether the remand is to be given or the accused is to be forwarded to the judicial custody or bail to be granted. Now, as you mentioned that you will try to establish before the court that the person can flee from justice or he can tamper the evidences, so bail should not be granted.
Right, sir.
But still, what the material thing you will produce before the court on the basis of which the magistrate will get convinced?
So I'll try to produce prima facie evidence that he has committed the offense, and therefore, since a prima facie evidence is present against him that he has committed the offense, he should not be granted bail, and his presence is necessary.
So it is a very initial stage, right? Because the police had arrested a person within the 24 hours they had produced before the magistrate. So it is a very initial stage. It is quite possible that there is no yet evidence yet collected. Then
So the FIR, the case diary,
hmm,
all those can
case
be
diary
produced.
is the appropriate thing which you will mention,
Right,
right?
sir.
So let's suppose the case diary is given in the court. So what are the particulars which are there in the case diary?
So the case diary is required to contain all the day-to-day particulars that have been undertaken by the police during their investigation, the time during which they started their investigation, what were the day-to-day activities that they undertook, what all statements were recorded, and from whom, what places were visited. All those details have to be written down into the case diary.
So just tell me, let's suppose magistrate had granted bail to the accused. How that bail can be cancelled?
Sir, if in case the magistrate has granted bail to the accused, there are grounds such as the accused has violated the conditions of the bail, or second, he has been trying to tamper evidence or threaten the witnesses. He's at flight risk. All those grounds can be used to cancel the bail.
Okay, coming back, Ekta, just tell me one thing that let's suppose the concerned accused person had violated the conditions of bail, right? Now, in that scenario, can any other magistrate cancel the bail?
So, the Sessions Court may cancel the bail. The Sessions Court or the High Court are allowed to cancel the bail.
But the magistrate who had not released the person on bail, do he is in the capacity to go for cancellation?
Sir, I'm not certain, but I believe he can cancel the bail. If the conditions of the bail have been violated, then he can cancel the bail.
So, but the journal rule says that the person who grants bail, only that person can cancel.
Yes, sir. The magistrate, that's what I said, that the magistrate who had granted the bail can cancel the bail. But in extraordinary cases, the Court of Sessions and the High Court as well may cancel the bail.
Suppose judicial magistrate first class has granted the bail. So, can it be cancelled by chief judicial magistrate?
So I believe only the High Court or the Court of Sessions or the magistrate himself.
Okay. So, whenever the court grants bail to any person, there is a bond, surety bond, which is required to be executed. So, how the courts see, like, what should be the amount of bond to be asked to be executed by the person?
Um, So I believe it is according to the circumstances in the financial condition of the accused, taking that into consideration. The amount of surety is fixed, plus the amount of the bond is fixed, and the sureties are also taken into account, and their identification, etc., has to be recorded.
My next question to you is that suppose the test identification of the concerned accused is not yet done, and the accused person is moving a bail application before the court.
Yes.
Now, can you raise this argument before the court that the bail should not be granted because TIP is not yet conducted?
So the criminal procedure provides that the fact that the identification is still pending is not a ground for refusing bail to the accused person.
Okay. Suppose an application is filed before the magistrate under 156(3) CRPC or 175(3) BNSS, and he is mentioning before the court that the police has not lodged the FIR and they are not conducting the investigation. It is an application moved by the concerned victim, right?
Yes.
Now, in that scenario, what things the court will see at the time when that application is to be disposed?
So may I please, I seek your pardon. Can you please repeat the question again?
My question is, there is an application moved by the victim that the police is not recording an FIR or they are not investigating the matter.
Yes, sir.
Now that application is filed before the magistrate under 156(3) of the CRPC or 175(3) of the BNSS. So while disposing that application, what things the magistrate will see firstly?
So the magistrate will inquire whether the investigation authorities, what is the reason why the investigation authorities they are not registering the FIR. They will go into the matters under the new BNSS. An affidavit would also have to be submitted, and after that only the magistrate will order registering of FIR.
Do the magistrate will hear the police officer also?
Yes, sir. Along with the affidavit, currently, as per the BNSS, the police officer would also have to be heard.
Okay, so supplementary charge sheet. Do there is any limit that how many supplementary charge sheets can be filed?
There's no limit as to the number of charge sheets, but the current BNSS it provides that the supplementary charge sheet would have to be the sup would be the so any further investigation would have to be finished within 90 days.
Are you sure?
Yes, sir. Within 90 days, a further investigation would have to be concluded.
You can take a second thought on this.
That's what I remember. I may be wrong, sir. Uh,
So
but
that
that's
this period is basically in the scenario when the trial has already started and the police is conducting further investigation.
investigation. Yes, sir.
In that scenario, they have to complete it within the 90 days
Within
period.
90
But if
days.
the trial had not yet started, there is no limit on the time period.
Yes, yes.
Right?
There's no limit.
Okay, so as I said, like in the BNSS, it is appearing to be more victim centric. So, do the police officer is duty bound to inform to the informant with respect to the status of the investigation?
Yes, sir. That has also been introduced into the BNSS. That the police officer, after they've started the investigation, they would have to inform the informant as regards to the progress of the investigation.
Do there any time limit is there for that?
So so I am not certain. I would be taking a guess. I'm not certain on the time limit.
It is a 90 days period.
Okay, sir.
Okay, just tell me, as you have done your LLM in the criminology, right? It is,
Yes, sir.
it was your branch. So, with respect to the examination of the witnesses, there is a
Yes,
very
sir.
important stage that is cross examination. Suppose you are appointed as APP, and during the trial, you want to go for the cross examination of the accused witnesses, like opposite party witnesses. Now, at the time of cross examination, what things you will consider?
Sir, at the time of cross-examination of the defense witnesses, um, sir, first of all, I'll try to impeach the credit of the witnesses by inquiring into their identity, by inquiring into what is their history, or whether they are only stock witnesses. Or secondly, I'll go to shake the credit of the victim of the defense witness. Anything that they've already been bribed or all that cases I can take into consideration in order to shake their credit. And
The
other
whole
than that,
the whole purpose of cross examination is to shake the credit of the witnesses.
no, sir, the purpose is to shake their testimony as such, that they are probably lying or they're not, their testimony is not reliable.
Is it not the purpose of the cross examination is to discover the proof of the relevant facts?
Yes, sir. Relevancy is something that I would obviously object to, that the evidence of the witness is not relevant. But if once it has been, apart from relevancy, sir, if after that the shaking of the testimony would come into place.
Hmm.
But yes, the relevancy would be objected to at the first stage itself.
Okay, just tell me, with respect to the discovery statement, let's suppose the police had investigated a case and there are certain discoveries which took place in that particular matter. So, how you will place those discoveries before the court because you are a prosecuting officer? So, how you will place those discoveries so that court will rely upon that?
So, the Panchnama would have to be produced before the court, and that is a very important document that has to be produced in order for the court to rely upon the fact that during the procedure, the accused was taken to the place and he or she was asked to point out to the place or to reveal the information that led to the discovery, and that would make the discovery statement reliable and relevant.
So, let's suppose there is no other evidences we are having, but only the discoveries are available. So, will the court go for the conviction?
So, basing the conviction solely on a discovery statement has not been held to be very safe. Usually, it requires corroboration.
Okay. Usually or always?
So solely it cannot be, a conviction cannot be solely based on a discovery statement.
Okay. Okay. In the new substantive criminal law, Bharati Nyaya Sanhita, Just tell me any five new offenses which are there.
The Section 69 has been added as a separate offense into the Bharatiya Nyaya Sanhita, which provides for the offense of having sexual intercourse with a woman on the pretext of marriage. That has been provided as a separate offense. Other than that, mob lynching has been added as a separate offense, and a separate uh, punishment has been provided for that. Um, so currently, those are the two that I can recall, the new
There are very
offenses.
important three offenses which are incorporated in section 111, 12, 13. Had you heard about the term organized crimes?
Yes, sir. So the
Hmm.
organized crimes, the offense has been separately incorporated as organized crimes. Um, and also, sir, now that I recall, there's another offense which has been added, uh, threatening the sovereignty and integrity of India. That has been added as a separate offense,
So
a new
earlier it
offense.
was which offense?
So this is a new one. Earlier there was a similar offense which was called sedition, but it was taken down by the Supreme Court. But now it has been sedition has not been incorporated. In the place of that, a similar offense has been added.
Are you aware about any judgment related to sedition in which Supreme Court had stated that new cases should not be registered under that particular section?
Yes, so there was a Supreme Court judgment. Sir, I'm unable to recall the case name right now. But the Supreme Court had ordered that no new, till the time we are examining the constitutionality of the offense, no new judgments should be, no new FIR should be registered under the case.
It was SG Wombatkere case?
SG Wombatkere versus Union of India. Yes, sir.
Okay. Just tell me, like, what is the basic differential between the terms abduction and kidnapping?
So while kidnapping is it's a continuing offense. It is kidnapping is a continuing offense, and abduction is a one-time offense.
Is it
And
not you are using
abduction,
it interchangeably?
so I stand corrected. Abduction is a continuing offense. Kidnapping is a substantive offense, and abduction also it has to be accompanied by some illegal object in order for it to become an offense. Kidnapping is per se an offense as soon as a person is taken from the lawful custody of the guardian. Then kidnapping takes place.
Okay, just tell me, like, let's suppose someone wants to come to Himachal. So, which places you will recommend that person to visit?
So I would first of all recommend them, since they would be they might be entering from Una, so I would first of all recommend them to take the blessings of Mata Chintapurni temple, and then they could go ahead and visit Dharamshala and McLeodganj. They could visit, which is a great place. Also has Buddhist architecture and Buddhist temples. Other than that, there are various places such as Khajiar, which is known as the mini Switzerland. It's a very beautiful place to visit. And then there is the beauty of Shimla, which has a lot of British architecture and a colonial architecture. And I believe those are the few places that they should visit.
So, you had mentioned that you had visited Pondicherry also.
Yes, sir.
So, what kind of visit it was?
So it was an excursion with my friends.
Okay.
It was a vacation.
Hmm. So, what kind of things you had seen over there?
So we found that it was a French, since Pondicherry was initially a French colony, so it is full of French architecture, and there are a lot of French people still who have settled there. And apart from that, I visited a very unique place called the Swaram, which is a natural which is a place that they've made musical instruments out of nature's products itself. So other than that, there is a man-made village in Pondicherry. And there are a lot of other places and beaches. Other than beaches, there's a lot of culture to witness in Pondicherry.
Okay. Okay, good. Can you please tell me where is Rivalsar Lake situated in Himachal?
So, so I'm not sure about the district.
Where is Manikaran Temple?
So it's in Mandi.
Are you sure?
So I'm not sure about the district.
Had you visited Manali?
Sir, I've not visited Manali.
Okay. Okay, Ekta, my last question to you is that why you should be selected and what are the cogent reasons behind that? Like, what is your self-assessment with respect to the post of ADA? Whatever you want to say.
Sir, I believe the post of an ADA, it is a very crucial one in order to ensure that the justice is secured for the victim by presenting the right evidence in the right manner before the court. And I believe since I consider myself as a disciplined and a person who usually has a keen eye for detail, I believe I would be a right fit for the post of an ADA.
Okay. Okay. Thank you so much, Ekta.